not rise.
Good afternoon.
Before lunch we were looking at the Z case, and there's a few more passages from that.
Just tell us before we start, when will we finish? What have you arrived at?
I'm aiming to finish by today, but if not, Milena Friend said that I could take up to half an hour tomorrow and she'd feel comfortable with it.
All right, thank you. Thank you very much.
Yes, your Lordship and the Chair was asking me about why didn't you just say, well, this is a charity and that I've done with it in the Z case. The Charity Commission wasn't represented in that case, of course, and there is no reference. I mean, I've just done it in the case to any positive decision by the charity in relation to the Section 193 issue prior to, so it differentiates the situation of this case from theirs.
So what is your submission, that it is a decision of the Charity Commission in relation to 193
yes.
that protects you, or is it that you are a charity?
We are a charity and we have been asked by the Charity Commission to explain.
Yeah, so it's the first of these, namely that the Charity Commission has considered the matter.
The Charity Commission has asked us to produce evidence that shows we are in compliance with Section 193, and it appears to have been satisfied on that evidence, and we've been permitted to maintain charitable status.
Right, so your case isn't, and it doesn't need to be, that even if the correspondence hadn't existed, Ofsted would have no business considering it.
Well, the case would be that I'm not sure that Ofsted would have the authority to make a decision under Section 193. I say that that's a matter for the Charity Commission, and that the regulator should be, when it comes to is there a breach of Equality Act provisions by a charity, the relevant provision is Section 193, assuming that one can say, actually, we have these restrictions which restrict a benefit on the basis of a charitable instrument. If you can do that, then that's a Charity Commission matter for it to consider.
Right, so in fact, because I'm anxious to bottom out what you're saying about this, in fact your position is Ofsted has no business looking into this, whether or not the Charity Commission has done so.
The position is that the Charity Commission has done so, but even if the Charity Commission had not done so, it is a matter in which, in this case, because of the facts of this case, because our charitable instrument allows us to impose.
Yes, but
these.
I think the answer is we're agreeing, aren't we?
You're
agreeing to my proposition.
It's not, I'm sorry, my Lord, we are agreeing in terms of the conclusion, but it's a question of how one gets there. And and the problem with your Lordship's question, if I may say, is that it flattens out why it is that I'm getting to the conclusion.
No, I understand what the steps in it are, but I'm wanting to see what the depth and breadth of your submission is.
But
and the depth and breadth of it, as I understand it, is that the fact that you're a charity means that Ofsted has no business in inquiring.
No, that's not it. And again, your Lordship is concertining my position and perhaps not getting quite the position which I'm attempting to.
Explain.
And it is this, that this is a charity which has within its charitable instrument provisions whereby the benefits are restricted to certain parties on the basis of religion and belief requirements. That is the relevant factor. Not all charities will have this, but this charity does. Against that background, Section 1, that we are therefore in the four corners of Section 193, and the decision on whether or not one has complied with 193 is a decision which Parliament has entrusted with the Charity Commission, because it is a decision which is centrally about the relationship between charity law and equality law.
Yes. Well, the only question I'm going to give up, if we don't resolve it now. The only question that I was asking is, your case does not therefore depend upon the correspondence in 2008 through to 2011. It's there, and I understand the place that you assign to it, but it's not essential for your submission that that correspondence should have taken place.
But it is essential to the facts that the correspondence did take place, and we are in the particular factual situation in which we are, which differentiates, because your Lordship was asking why is the Hackney case, why didn't we say, well, this is a charity and that's it? Well, I'm saying there are two important differentials in that we have had a process initiated by the Charity Commission, which we have responded to their satisfaction, which didn't happen in Z. And secondly, we have, as is not clear from Z, we have a position in which we have a religious requirement imposed under our charitable instruments, which has been known to and approved by the Charity Commission since 2007. So in those circumstances, of those facts, which mean we are squarely within the realms of 193, on the basis of Z, the court is telling us that the appropriate regulator in such a case, because this is a difficult and sensitive area of charity law, is the Charity Commission. And other regulators who will come in will not have the expertise, background, knowledge, or even the statutory competence to determine issues around charitable benefit and the weight which that comes into in terms of the proportionality analysis required under section 193(2)(a). I'm sorry if that's a long-winded answer, but it is important that we do not cut to the chase on this. So staying with the Z case, at page 1031, paragraph 105, Lord Sales continues, when giving reasons as to why the proportionality exercise does not, one is the same as under the ECHR and under EU law, and charity is not therefore subject to multiple tests, multiple hoops to jump through. He says, this is the benefit for charities that where they rely on section 193(2)(b) limit of exception, they do not have to produce a separate proportionality justification of their own if challenged. But of course, in our case, we have produced a separate proportionality justification on being challenged under 193(2)(a), so we have done the work. This means, he goes on, that their resources will not have to be used up in this way in meeting challenges which may be brought against them. And since section 193(2)(b) provides a defence with bright line characteristics, and the same can be said for 193(2)(a) once it has been passed, it is likely to protect them from challenges being brought which can be seen will not succeed. In this way, the limb of the exemption in section 193 as a whole, as framed, helps to ensure that the scarce resources of charities are channeled through to those who need them, rather than being diverted to meet costs of administration, legal proceedings, and threats of legal proceedings. And that applies directly to this case, where we have gone through the hoops for the Charity Commission and been found to be able to maintain our charitable status, but yet we are now before this court because another regulator has decided that the Charity Commission misunderstood section 193 and is making its own decision. That is contrary to the policy of Parliament as set out in paragraph 105 by Lord Sales. He goes on at paragraph 106. It's also relevant that it is the state's, not charities' responsibility to provide essential welfare benefits for all who need them. It's easier to say that Parliament has struck a fair and proportionate balance between the needs of charities, and particularly those who benefit from their activities, and the general interests of the sections of the public who do not so benefit, when those general interests are met out of state resources where there's a pressing need. Again, mutatis mutandis, that is the case here, that the Cornerstone do not have a monopoly on the provision of fostering services. It is supplemental to that which is provided by the state as a whole, and the state as a whole does allow for gay couples, same-sex couples, individuals regardless of sexual orientation to foster and adopt. So there's no exclusion by maintaining Cornerstone's position. The margin of appreciation goes on to be afforded to Parliament when it is sought to strike a balance between competing interests varies depending on context. And as I say, context is everything. Charitable law context is important. Whereas here, Parliament has had its attention directed to the competing interests and to the need for the regime it enacts to strike a balance which is fair and proportionate and is plainly legislated with a view to satisfying that requirement, the margin of appreciation will tend to be higher. The court should accord weight to the judgment made by the democratic legislature on a subject where different views regarding what constitutes a fair balance can reasonably be entertained. Now that again is directly on point with us. Of course, the court might have a different view on where a fair balance in the circumstance of this case may be placed. Of course, Ofsted clearly do have a different view on that matter. But the important point is that the specialist regulator appointed by Parliament has taken a view, and that view has not been challenged or overturned or reconsidered by that regulator. And at paragraph 109, it goes on. He says that it is also a matter of social and economic policy for Parliament to decide how best to stimulate private benevolence, which will allow charities to supplement state provision of welfare benefits. The degree to which charities are given freedom to pursue objectives which their donors regard as important affects the extent to which donors will provide private resources to supplement provision of the state. If donors are not given reasonable assurance that they will, what they give will reach the person they intend to benefit, they will not give at all. And that is seen to be part of a potential disbenefit, and why it is that a different approach to proportionality is applied in relation to charities and is applied by a charity.
Will you just read the last sentence of that paragraph to save me coming back to it?
Give it all. It was a legitimate policy choice by Parliament to fashion the exempt for charities under section 1932b lim of section 193 in the way it did as a relatively bright line rule that would give assurance to that donors. Well, it applies equally to this 1932a, so I'm not sure what...
This case is not about donors. You're funded by local authorities.
Well, not completely.
And at least if I say it's not about donors, I don't remember reading anything in the evidence or the judgment about Cornerstone relying on donation as opposed to acting to provide services through local authorities.
Cornerstone provides services and the evidence which is before the witness statements as part of the expression of belief for a specific Christian community which supports it, the evangelical Christian community, and we're told that it therefore gets foster carers from a wider places across the country from that evangelical Christian community, and that they are encouraged to participate as members in this charity precisely because of its religious ethos. So the point is not restricted to where do you get your money from. The question is, are you an expression of a broader community support?
I understand that also, but it's a very fair point. But where was the evidence in relation to the fact that people would be deterred from fostering these deserving children? And a very good piece of work it is to do that. I accept that unhesitatingly. Where was the evidence that either people would be deterred from coming forward or that the pool of people who would foster for you was reduced?
Well, the evidence is that there is a Christian ethos which has encouraged people to come forward and who are, on Ofsted's own report, given fundamental support, given resilience in the manner in which they continue, are able to adopt difficult to place families, take on sibling groups, proceed to adoptions with a far higher success rate than in private agencies and or local authority agencies, and that is ascribed by the foster carers and noted by Ofsted to be because of the spiritual support which they receive as evangelical Christians through the specialist faith-based support which Ofsted notes through prayer and sharing and communal worship and the like. So that's the evidence which Ofsted has itself in terms of the positive good which arises out of the application of these religious belief requirements. And there is, and no doubt Leonard Jr. can double check, but there are of course 3 witness statements from the principal of this who speaks generally as to how Cornerstone has impacted in the evangelical Christian community.
And Mr O'Neill, I think there is some reference somewhere to, at least an assertion, that framework, structure, support would be undermined if one had people who were not in heterosexual couples.
Yes.
I think that's right.
I think who were not evangelical Christians. I think it's at paragraph 8 of the letter of 30th November 2010. I don't know if that's the passage.
But there is something to that effect.
It's not that they're heterosexual, but if they weren't evangelical Christians, then they would be able to comfortably and appropriately pray.
Participate in those support networks.
And there are enough cases of cases where people have found praying for, has been inappropriate and unwelcome and unwanted as an imposition of religious views, and some people are very uncomfortable about that. And so I think what's being said there is if you don't have fellow evangelicals believing it, we're trying to avoid that discomfort on both sides for those who are attempting to pray in good faith. They need to know that their prayers are welcomed, appreciated, and accepted, rather than seen as some kind of religious fanatical intrusion on their lives. I referred to a passage in Pamela Birtle's witness statement by Leonard Jr., which I hope assists. I haven't quite been able to find it. It's in the supplementary bundle at tab 7, page 94, paragraph 6 following.
Page 94, paragraph
6 onwards, I'm told.
Thank you.
Seem to deal with the point that we're concerned with. But the point that you make, that you made in your submission, is something that we've come across in the evidence, including the evidence you took us to this morning.
Because, in a sense, this evidence is responding to suggestions by Ofsted that, well, you can go and pray in another room or the like, or, you can, as it were, keep your religion in a forum internum, and so you won't get embarrassed and people won't be embarrassed by you. We say that that's responding to that as to why that doesn't make sense within an organisation with the evangelical Christian religious ethos. But in any event, it's not for Cornerstone to tell, for Ofsted to tell us how to practice our religion. So, I say against the background, as is clear from the Z case, of the importance of the charity law considerations and the expertise which is afforded to the Charity Commission, we say it cannot be the case properly for the Charity Commission, as in this case, to reach a view in terms of section 193 that the religious belief requirements on foster carers does not contravene the Equality Act 2010, which is inclusion falls from 193, and yet for those very same requirements, that very same practice, to be found to be contrary to the requirements of the Equality Act and or the Human Rights Act, if it is to maintain its operations as an independent fostering agency.
It's a feature of this situation that nobody's drawn the Charity Commission in, either below or here to deal with this point, nor did they in Z if that was an issue there.
I'm sorry, my lord.
Nor did they do it in Z if that was
yes,
an issue. If that was really an issue there, which I appreciate is contested.
Yeah.
But staying with our case.
Well, all I can say is it's not for us to, we say that Ofsted's decision was unlawful. We point out to the facts. It's Ofsted now who are saying, no, the Charity Commission have misunderstood the law, another statutory regulator has misunderstood the law. If anyone's properly should have brought in, Ofsted should have called in the Charity Commission to. But there it is.
Yes, I'm not in any way laying that at your door. It's just looking at it as we do now. One might have thought that if the Charity Commission was being awarded the, as it were, the only tool in the box for this, then it would have been of interest to know what they thought about it. We'll have to do our best with what we've got.
But indeed, we've got to work on what the law is, and the fact is that the central role of the Charity Commission was underlined and emphasised by Lord Sales in Z when there was no participation of the Charities Agency, and it was in any event simply repeating what it already said in the Catholic Care case and what Mr Justice Briggs, as he then was, had said in Father Hudson's case, that this is a matter for the Charity Commission. So the Charity Commission, in a sense, knows where it stands without having to. But there it is. I mean, the court has what it has. Now, at paragraph 11 of the note of argument, the Ofsted picks up the claim made in the court below that there's no problem with overlapping statutory regulators. After all, the Health and Safety Executive might overlap in terms of statutory regulation of health and safety in particular premises. You know, where's the issue there? But of course, the issue there would be if the Health and Safety Executive had come in and given a place a complete clean bill of health on a health and safety grounds and said, yeah, we've done all the inspections and you're fine. And then Ofsted come in and say, no, you've breached the Health and Safety Work Act 1974 sections X, X and Y. Fix them, otherwise we're taking away your chargeable status. That would be a problem. You then say, just a minute, we've been told by apparently the specialist regulator that we're fine. On what basis, particularly since you haven't challenged what the previous Health and Safety Executive had said, on what basis are you coming and saying, well, we've taken it into account, but we're ignoring it, they got it wrong? That would be problematic. That would be, at some levels, regulatory harassment. That it's all very well to say, well, we can do we can take into account what others done, but we're not bound by them, and you can still come in and subject a charity, in this case, to go through hoops that it's already jumped through. That would be contrary to the balance which we have seen. Lord Sales has said at paragraph 105 of Z. This charity should not be being required to spend its resources in going through different authorities.
I understand the difficulties that it may place, but let me just give you a trite example. Let's suppose I go to a garage and get an MOT test. I pass my MOT, and when driving home, the police stops me for a bald tyre which hasn't been spotted. Am I able to say, well, regulatory harassment, I've got an MOT certificate this morning?
Well, you can certainly say good faith, and that you certainly can't be charged with not having an MOT certificate, and you can put forward issues around reasonable excuse. So I think it makes a difference. I mean, I'm not a criminal lawyer, but I would have thought.
But I mean, your argument.
The police are acting unreasonably in pursuing, charging me with something when I've got all the evidence and I've got an expert who looked through it, and so it's not my fault. So yes, it does make a difference.
I just think we have to look at the implications for your argument, which go, it seems to me, far beyond charity law.
Well, I don't think they do, and I fear that creating hypothetical examples such as Ofsted have done distracts the court from its proper course. And of course, it's always easy to say, yes, but what about, or what if? The fact is that this is a charity law case on a specific issue about Section 193,
yes, but that's exactly it. So we have to decide it on this case, on that particular section,
statutory provision,
and what it means, so that when we get arguments about this is harassing, that we get done more than once, or we get inspected more than once, these are considerations which only can feed into the policy of Parliament in that section.
Yes, but the other fact to bear in mind, again, if one wants a bigger picture, it's not about police and MOTs, it's about what is the proper relationship of voluntary associations with religious basis in a democratic society. That's the kind of approach which the European Court of Human Rights places that in, the importance of subsidiarity, of pluralism and tolerance, and we've seen that Lord Sales picks up and mentions the importance of those, which won't necessarily be engaged by your motorist being stopped by the police with a bald tyre. This is, if you want a broader approach, what it is for a properly democratic society to allow for different forms of life, as it were, to say, actually, we don't necessarily have a uniform approach with all the answers. Certainly, if we are state bodies, then yes, one can have as a matter of state law, but a democratic state is one which also allows associations with different views and different approaches not only to be formed, but to flourish and participate in the public square. That's what this case is about. So, at some levels, if you want to see different examples of that, then the recent American case of Fulton against the City of Philadelphia is useful, because you have exactly the same issue, almost entirely on all fours, but it is considered within a broader constitutional perspective of the relationship of the free exercise of religion, of the possibility of religious associations forming associations and working in the public sphere against the requirements of what a proper constitutional state should be. So yes, look at the broader implications, but that's the context in which to make those judgments. Paragraph 12 of the note of argument, Ofsted say, well, we've got to be able to apply, at least as I understand it, we've got to be able to apply equality law and human rights law to independent fostering agencies across the board. Some of them are private agencies, they won't fall under the provisions of the jurisdiction of the Charity Commission. So therefore, they've got to be allowed to have a consistent approach to charitable and non-charitable agencies and their approach. Well, that, as we've seen from Z, the fact is that being a charity does make a difference, because you are in a completely different sphere of law in which all sorts of regulatory issues have been gone through and benefits have been balances and judgments have been made, in particular in relation to public benefits. So charities are not the same as commercial organisations, for-profit organisations, even if they happen to be working within the same sphere. So yes, there is a differentiation in approach potentially, but that's a consequence of the regime which Parliament has created. And it doesn't in any event face up to the problem that the Charity Commission have reached a view on the lawfulness of these regulatory requirements, of these religion belief requirements, whereas Ofsted now takes a diametrically opposed view. So inconsistency comes back in. If not within Ofsted, then Ofsted vis-a-vis the Charity Commission. And the point I've already made is, of course, that there is no mention in the relevant provision under which Ofsted is working of the Human Rights Act and or the Equality Act as being relevant enactment. It is simply a matter which Ofsted has chosen as part of its current policy to take up, it would appear. As I say, we have specialist regulators in the field of equality and human rights, which is the HRC, which has powers, which also is given statutory standing without the need for victims and powers of enforcement in that way, vis-a-vis so there are specific powers of enforcement which the equality.
I mentioned the HRC earlier on. Where does this leave them?
Well, they've known about this case. They also were, as I understand it, there was correspondence.
No, but I think the logic of your argument is that they'd be no better off than Ofsted in enforcing any perceived breach of equality legislation.
Yeah, that in terms of Section 193, that is a matter of the Charity Commission. In terms of other enforcement, such as Ofsted is attempting to do here in terms of Section 13 and 19, it's the HRC who should be doing that. Otherwise, you have all these regulations applying the same statutory provisions to the same complained of requirements, and potentially reaching different views, or potentially, which does, when you're dealing with a charity, which is a religious organisation, does raise problems. A lot of the EHRC, the Strasbourg case law on these matters are to do with frankly the Russia and the regulatory approaches taken in Russia, particularly to religious associations which are not non-Russian Orthodox, but anything slightly out there. Jehovah's Witnesses certainly get a problem, but the Salvation Army was deregistered because it was said to be a paramilitary organisation, and was subject to, in the Moscow branch of the Salvation Army, a whole series of regulatory hoops and requirements to change its memoranda of association and articles. And that issue of the state using its power through a variety of agencies, the Department of Justice, various courts, was seen to be problematic from the point of view of the maintenance of those broader constitutional issues of a pluralist society. So, mutatis mutandis, the same applies here. It cannot be a free-for-all for any statutory regulator says, look, it just says relevant enactment. I consider the Human Rights Act to be a relevant enactment. I'm going to come in, say, for example, as the Health and Safety Executive, and say, look, you're breaching. I think
we've got this point now. What I'd just like to have some sense of where we've got to, because we're now well into the afternoon and we haven't so far formally departed from ground one, which I'm quite sure we've grasped the argument on. So where are we going now?
We're almost finishing ground one, and then we're going on to grounds 2, 3, 4, and 5.
Thank you.
Mr O'Neill, though, am I right in, you said before the short adjournment, that once the Charity Commission had made the kind of decision that it made in that final letter you referred us to, that was it, done and dusted. I'm just wondering whether under the Charities Act there is any means by which someone else could question that conclusion, whether it's built in therefore to the Charities Act. You may not be in a position to answer that now, but perhaps you think about that.
I will. It's a very absolute question, if I may say, my lady. Yes, I'm sure there must be.
Well, please.
But I will double check on that.
If you report back to us, we'd be grateful.
I'm very much obliged. No doubt my junior's on to it even as we speak. Before I leave the section 193 point, there's still a couple of arguments to be addressed, which Ofsted have put forward. One of them is that they have to make this decision about compliance with equality law because of section 149, the public sector equality duty requires them to do that. That argument is wrong. Frankly, it proves too much. All sorts of organisations are subject to public sector equality duty. That doesn't invest them with jurisdiction if the regulators to ensure the compliance, as they see it, with equality law by those subject to the regulation. In any event, we know that section 149, public sector equality duty, is not a question of reaching results, but is a matter of undertaking a process. And if we need authority for that, it's in the Davies Royal Imperial Society case, which is at tab 16, page 442, paragraph 144. But I don't need to go there. So basically, section 149 is not a magic bootstrap which invests Ofsted with jurisdiction, as Ofsted claims it can do. Paragraphs 14, 15 of the Ofsted's note of argument basically tries to unpick the decision of the Charity Commission. Says, oh, it's wrong in law, they misunderstood this, they haven't made it clear what the reasons why they reached the decision. But of course, none of this has been put to the Charity Commission itself.
Well, you dealt at length with that letter for the short adjournment.
Yes, I did. And I'm just placing it in terms of my response to their note of argument for the sake of the court's notes. And one of the claims which they make at paragraph 14 is that the Charity Commission has made no finding as to the applicability of the exemptions relating to sexual orientation discrimination. I say that betrays a complete misunderstanding of how section 193 works, which is, as we've said, and apologies if leadership's already got the point, one which means that the Act as a whole does not apply. Because the misunderstanding of section 193, which Ofsted are putting forward, is plain when you actually unpack what the reading requires when they say you've got to differentiate, or the Charity Commission was only giving a pass on religious belief requirements but not on sexual orientation requirements, is that their reading of section 193 is this. They're saying that a person does not contravene this Act's provisions concerning discrimination because, and this is the additional words, this Act's provisions, and we'll add this, concerning discrimination because of or in relation to a protected characteristic, only by restricting the provision of benefits to persons who share that protected characteristic. They have to bring in that kind of restriction and tie up the two. Yes, you've been given a pass on your religious discrimination, your religious requirements, but only in relation to you can't be found guilty of religious discrimination. That's not what section 193 says. Ofsted is wrong when it says it, which is another reason as to why they should not be entrusted with or should not be seen to have been given the jurisdiction in relation to this matter. So that concludes where I've got to on section 193, and I'm sure the court will be glad to know I'm going on to the next grounds. But I have to contextualise those next grounds in relation to the issue of the contradiction which we highlighted in the note of argument. The first contradiction was you can't have all these regulators making decisions on the same provisions. But the second contradiction is the manner in which the court has apparently said, yes, you can discriminate. Of course, your provisions for religious belief requirements are lawful, so long as, except they're not really lawful because they're unlawful because they breach sexual orientation requirements. So they're both lawful and they're not, which is why, of course, then I think the court below then attempting to square that circle, realising it's got itself into deep conceptual waters, then invents a new category of, well, you can maintain your requirement of evangelical Christian so long as you allow for gay evangelical Christian, on which there had been no evidence at all, and the evidence we now have shows why that is misplaced. But given that as it were, squaring of the circle cannot be done on the evidence that we have, we are left with an incoherent judgment, which has been accepted by Ofsted, that it is lawful, both under the Equality Act and under the Human Rights Act, for Cornerstone to impose their religion and belief requirements on foster carers, but it is unlawful for them to impose those same religion and belief requirements because of concerns about sexual orientation. It cannot be both, as the court below has said and as Ofsted has accepted. The fact is that if you accept, as the court below has accepted, and Ofsted also now accept, that the religion and belief requirements are justified and lawful, that is an end to the matter. There is no need for going into the abstract speculations of whether it should then be reanalyzed as having implications in terms of sexual orientation discrimination. It has been justified in the terms considered by Parliament and has followed the requirements of the Convention as understood by the court in Z. As the court below says, so far as discrimination, he says this at paragraph 284, so far as discrimination on grounds of religious belief is concerned, I have concluded that Cornerstone's policy is objectively justified. And he then goes on at paragraph 286, it would be fundamentally incompatible with Parliament's intention to hold under Article 14 ECHR that a religiously based fostering agency cannot restrict its services to applicants holding the same faith. And those findings have not been appealed against. But if we have, and if we do accept that the Cornerstone's policy is objectively justified and isn't unlawful discrimination on grounds of religious belief and is compatible with Article 14 that a fostering agency should be able to restrict its services to persons holding the same faith, it is not then for the court, as this court has done and the court below has done, is to tell them what that faith really is. And if you only understood your own faith better, you would find that you would be welcoming gay people as carers, and there wouldn't be any issues around sexual orientation discrimination. But that's all rather strange, actually, because the religious requirements which have been found to be justified and lawful by the court below and accepted to be so by Cornerstone are the very ones that we've looked at some detail, which includes a prohibition on homosexual behaviour. Given that that is justified, how can it then be said, but it's not justified? The only way around that is that actually what we're saying is justified is another religion or belief requirement which you are not currently imposing, but we think that you should if you really are properly Christian. Now, that is overreach. It's an attempt. The fact is that there were arguments that were put forward by Ofsted. This is what you can do to practice your religion in a way which we think is acceptable to us, and the judge has picked up on that and run with it. Now, of course, how did we get into this pickle? Is because Ofsted's approach originally was that the requirements were unlawful, not just in terms of equality law, but in human rights law. The religious belief requirements were unlawful discrimination contrary to Article 14 on grounds of religion or belief. That's what they said, and that's how they approached it. So therefore, that makes sense. If it is indeed unlawful, these religious belief requirements are unlawful because they discriminate on religious grounds and on sexual orientation grounds, then they're unlawful. But the fact is they lost that argument before the court below. They presented it and it was rejected on the basis, as the court probably held, is that if the religious belief requirements are justified under the Equality Act, they can't then be impugned under the Human Rights Act. It's not a way, you can't, as it were, dodge round and say, haha, but we've got you qua public authority. And the court was right to do that, and it in fact was following actually the approach which subsequently was spoken to in Z about one has to respect the margin of appreciation, the structures which have been put in place by Parliament when making those decisions on proportionality and justifiability. Now, Ofsted have not appealed. I know I've made that point, my lady, but it is important. Ofsted have not appealed the finding by the court that their claim that these regulations were HRA incompatible because in breach of religious rights, and that has been left standing. So, what does one do with that? How does one get around that? I don't think one can, because the only way round it is to understand, as I've said, that what in fact the court, in upholding two contradictory propositions, as it did, was implicitly, although it didn't spell it out, and Ofsted is doing the same, requiring the religious belief statements to be altered, religious belief requirements to be altered. And that is beyond, that is constitutionally improper, and it is not a basis which can be upheld by this court. Basically, in order to maintain those two contradictory provisions, you're going to have an amendment of Clause 5. So, Clause 5, as we've seen, says that the policy of the charity shall be to restrict employment and acceptance of applications for foster children, people to adopt or foster, through the charity to evangelical Christians, being those, and then giving a definition. So, those who shall have first signed the statement of belief set out in the schedule hereto, well, that's yes, we're not going to move that because that's a theological thing and we don't do theology, and that's what evangelical theology looks like. Okay, then we'll leave that. But then what they have to do is then take away the requirement of their personal lifestyle being consistent with the practice of the statement of beliefs and with Scripture, and put in something like, regardless of whether or not their personal lifestyle conduct is consistent with the practice of the statement of belief and or the code of conduct. So what it's saying is that religion's really just about what you think in your head, and they've signed up to the statement of belief, but it's nothing to do with conduct. And so we don't need to judge conduct against requirements of traditional biblical Christian morality. And in that way, therefore, you will therefore be able to get people who claim to believe in what evangelical Christianity believes in terms of intellectually, but who in their conduct do not have a lifestyle which is congruent or consistent with that. For example, being sexually active in a same-sex marriage or partnership. Now that's one potential change that the court is implicitly requiring. Another one might be that they want the clause 10 of the Code of Practice to be changed, because that's going to have to be changed too, isn't it? If one's going not to be discriminating on grounds of sexual orientation. So that would say something along the lines of foster carers have to set a high standard in personal morality which recognises that sexual intercourse is to be enjoyed exclusively within opposite sex or same-sex marriage. Take away the Christian marriage requirement, take away the reference to God's gift, because that might be controversial as to whether or not God approves. But exclusively within opposite sex or same-sex marriage, because that's what the state allows for. And abstain from all sexual sins, including immodesty, viewing of pornography, fornication, adultery, cohabitation, and extramarital behaviour rather than homosexual behaviour. Now, if those were the religious requirement conditions, then doubtless Ofsted would have no complaint that there's any discrimination on grounds of sexual orientation. But they are not the religious requirements which have been upheld as justified in terms of the evangelical Christian ethos of Cornerstone. What the judgment and what Ofsted is requiring, what the judgment below has agreed to, is that this redefinition has to, that Cornerstone, if they're going to continue to operate as a charity acting as an independent fostering advisory agency, have to change their category of membership, the religious category of membership, to include those whose personal conduct is not congruent with traditional biblical morality, and or to change their definition of marriage from Christian marriage to whatever a state currently recognises as marriage. Now, these are profound areas, important areas of constitutional law as well as of theological importance. But one thing I would say, again, looking at the bigger, broader constitutional issue, because one has to unpack what it is one regards as normal for the relationship between state and church, which is why the Fulton against the City of Philadelphia is a very useful comparator. Too often within English law, the approach has been to adopt what might be called an Erastian approach to the proper relationship between church and state. Because the Reformation in England, as opposed to in Scotland, in 1532 involved a top-down change, from the top, a replacement basically of papal authority for royal authority, but otherwise leaving matters relatively unchanged. We have the Restraint of Appeals Act and the like, the submission of the clergy and issues around that. It has become normal within English law's understanding for the state properly to tell a church, in particular the established church, what to think, what to believe, what to do. Now that is a peculiar relationship. Erastian relationships are not, I mean, they're not unknown in Scandinavia, Norway and Denmark. It's certainly not the only church-state relationship which exists within these isles. We know that, as I mentioned, Scotland, the Reformation there, it was bottom-up. It was despite the Crown not wishing it to happen, that it happened, and it imposed, an interestingly, a democratic structure of election of presbyters and a convocation of a General Assembly, as opposed to appointment of bishops. And you'll, of course, recall that when James VI came down to become James I of England, what he was really keen on suddenly was he got away from Presbyterians, and was now allowed to control the church by appointing bishops. Nae bishops, nae king is what he classically said.
But where is this taking us?
Where it's taking us is...
For example, we have the example of the Catholic Care Association now. Now they've got nothing to do with church and state. So where are we going?
Where we're going from it is I'm trying to unpack the presuppositions that one should not assume that it is normal for the state, as it might be specifically for the Anglican Church, to tell the church what to do, particularly in the context of evangelical Christians who are, at some levels, the separate church, the whole Calvinist approach to, and the two kingdoms approach. I'm just trying to contextualise it within that broader. Start questioning your assumptions about what it is proper for the court and the state to do in this case, and that is why looking at Fulton is important, because in a sense it encapsulates.
Well, Fulton is a case about the First Amendment.
Yes, the First Amendment is, and I'm so glad you brought that up, it's about the free exercise clause in the First
Yes.
Amendment. And the free exercise of religion is a constitutional principle which the American Constitution borrows from the United Kingdom. After the 1689 revolution, the Toleration Act, allowing for non-Anglican dissenters to be specifically part of the state where they had been excluded before, is precisely a case in which, as a constitutional principle, the exercise of religious freedom, the plurality of religious approaches, is embodied as a constitutional principle from 1689 onwards. Now that is important in this case because this case is about non-conformist, dissenting evangelicals who have a particular vision of the state, because we come back to this, have due regard to the law, not wholly subordinate to the law in some kind of high Anglican Toryist approach. It's important
I think that,
from that.
if I might say, I think these slights upon the Church of England and Anglican Toryism and all this is not directly in point at all, nor do we have any evidence before this court about the Church of England being ruled by the state or Toryism or any of those things, and they're all irrelevant, and I think that should be said.
I apologise, milady, I'm attempting to speak in the broadest brush terms, and I'm in no sense slighting
I'm
Anglican
not in any way feeling personally slighted, but I just think that it's a point that the court should make, because we have no evidence about any of those things before us. But I think that what you're saying just boils down, and I don't mean by just to underestimate it or trivialise it, but what you're saying is that in fact the state should not be intervening in what people believe, in their religious beliefs. And I think that's it.
Well, but it's not just what they believe, but how they live those beliefs. Yeah. And yes, that is it. And my apologies if I've my broad brush historical approach has not been there, but they are important principles. They're reflected. So the free exercise clause in the United States is reflected in the UK Constitution. It's reflected in Article 9 of the Convention. These are common values within the context of a properly democratic state, which respects the autonomy of religious bodies to determine their membership and to determine their doctrines. And this decision is in fact unlawfully going into the forbidden zone, impinging on both those matters, whatever the situation of the Anglican Church was in the 16th century as opposed to now. It's irrelevant, as your leadership quite rightly says. What is actually quite relevant, however, is that the position of the Church of England on marriage is, as been set out in thinking your leadership's judgment in Pemberton against Inwood, on all fours with the position which is taken in this case, where the Church of England considers marriage to be between one man and one woman. By its very terms, it excludes same-sex marriage as a matter of Church of England doctrine. It doesn't accept same-sex marriage as marriage at all, and that marrying someone of the same sex would be at variance with the teachings of the Church of England. So all this is pointing out that these religious requirements in this case, which refer to Christian marriage, are not, we're not talking way out there, we're talking central, mainstream, traditional Christian beliefs which have been unquestioned orthodoxy until very, very recently. There's been a revolution in social attitudes, particularly on the issue of sexual orientation within all of our lifetimes. But that doesn't mean to say that those who hold to the older traditional way are therefore in a democratic society which allows for pluralism, not given a space to maintain their position in society and to contribute to society rather than, as it were, being excluded from the public square, as was said, as if they were racist bigots, which was the parallel that was drawn in the Father Hudson case and the Catholic Care case, and was rejected by the court. So the sleight of hand which the court below carried out to reconcile the irreconcilable was effectively for the court to create a category of gay evangelical Christians, people who believe the statement of belief or subscribe to the statement of belief but don't live out traditional biblical morality, which is not what constitutes on Cornerstone's own express religious requirements what an evangelical Christian is. And Ofsted are saying, oh well, that's a peculiar and idiosyncratic and particular definition of evangelical Christian by Cornerstone. It isn't. The witness statement from the Reverend Mason makes clear how within the mainstream of evangelical Christianity that is. The issue about there being, as it were, a forbidden zone for the court to enter into is not simply a matter of ECHR law, although it certainly is usefully set out there. But some of the cases on that point are highlighted in the decision in EXP against the Watchtower and Bible Tract Society. I won't take the court to it, just give them a reference. It's a decision of Mr Justice Chamberlain at Authorities tab 17, page 446, and it's paragraphs 22 to 26. His approach was, I think, criticised before this court, but I think Lady...
I oppose his judgment.
You wrote the judgment, said actually he's got it right on.
Yes, I did. Yes. Right down the line.
Indeed, and I'm certainly not in any sense critical of that judgment, because it does set out and accept that the European principles to the effect that it is for religious communities themselves to determine issues on membership, what constitutes right doctrine, is something which is accepted in the English courts. And it is only in exceptional cases that the state will involve itself in religious matters where there's a dispute over legal right. And then sometimes the court is forced in to determine in a dispute between two parties as to which one is in fact legitimate.
Could we, this might be a convenient point, just a light upon the judgment so we can see what you are describing as the sleight of hand.
Yes.
If that's a useful term in any way. Is it paragraph 203 that attracts your particular criticism?
Well, the judgment at some levels goes at some length. That it's not just that paragraph. It is that paragraph.
I understand that, but I mean, I just want to see where
among the other paragraphs, paragraph 297, page 157, where he says, "I don't doubt for a moment," this is in relation to Article 9, that Cornerstone are motivated to do what they consider the provision of fostering and adoption agencies because it falls within Christian observance and fulfills an important biblical mission. As Miss Birtle explains, that belief is a religious belief. Also accept that Cornerstone wishes to encourage evangelical Christians to fulfil that. But I don't think that carers being evangelical Christians is sufficiently or intimately linked to the aims that engage Article 9. That's all the more so, he says, because Miss Birtle, in her first witness statement, says that they support children of no faith. From this, I understand her to mean that children who are not evangelical Christians are not sought to be converted. So that there seems to be an assumption that proselytism and conversion is essential to engage the respect that's otherwise required under Article 9. So then it says at paragraph 298, Cornerstone can fulfil, perhaps even more fully fulfil its Christian mission of providing homes by ensuring it has the widest possible potential carers and recruits, and by not restricting potential applicants to just one faith. That's a theological judgment. Can fulfil, even more fully fulfil its Christian mission. And then at paragraph 299, again, there seems to be a misunderstanding that the Article 9 relates to and applies to simply what might be called worship or prayer. He says, Cornerstone and its staff remain free to believe their Christian beliefs as they see fit. They can worship as they wish at a time and a place and a manner they wish. They can conduct their meetings with prayer and worship as they see fit. They're able to manifest those beliefs publicly if they wish. They remain free to evangelise, proselytise, again, proselytism is coming in, dispute and discuss, although, as I've said, they don't do so in relation to foster children. They can continue to supply an evangelical Christian framework and support network for their carers. The requirement that Cornerstone not discriminate against non-evangelical Christians doesn't impinge on any of its human components, which are closely linked to acts of worship or devotion. And then at paragraph 300 says, in short, Cornerstone can continue to have a religious ethos. That's important. The court says you can have a religious ethos, it's a religious ethos, whilst not placing a blanket exclusion on those of different or no religion. Cornerstone doesn't contend the role of foster care demands or is enhanced by a particular religion or belief. Well, yes, it does, actually. It says that its mission is enhanced by the manner in which evangelical Christianity is understood and expressed. Paragraph 303, I turn to the question of sexual orientation. I concluded that the non-recruitment of gay and lesbian foster carers is not a manifestation of religious belief. It doesn't have a close connection with Cornerstone's forum internum. Again, as if this were simply about what one internally thinks in one's head, rather than how one acts. The ban on recruitment of gay and lesbian carers doesn't directly express the belief concerned, is only remotely connected to a precept of faith. Evangelical Christian gay men and lesbians are full members of that faith community in every sense. Again, that's a theological statement on which there was no evidence.
It was with that in mind that I was suggesting 203 in the judgment.
Yes, as I say, the judgment is a long judgment, and there are...
Well, and it's, we've discussed the fact that many matters have to be gone through twice,
Yes.
at least. But I think you've gone to the Human Rights Act section of the judgment for these citations, but I think we find at 203 the point where the judge picks this point up.
Yes. Oh, you didn't want it.
I think, Mr. O'Neill, your point is the judge is wrong at 203 because there aren't evangelical Christian gay people who meet the criteria of Cornerstone, which is a theological statement.
Yes, and as we said before, and that's what Mr. Mason's statement applies to, is that there's a category error in assuming that the approach to membership of the church from a Roman Catholic perspective is the same as from the evangelical perspective. Yeah. Roman Catholic perspective is about baptism, and it doesn't matter about conduct, you remain a Catholic. As I've said, interestingly, that's one explanation as to why the current Prime Minister was able to marry in a Catholic church, although he would lawfully have been refused from a Church of England church for marriage in the sense that he remains a full member of the church.
All right, well, look, don't let's go there. Can we just stay with 203?
Yep.
The number of gay and lesbian evangelical Christians is obviously not known. This, you say, is the judge speaking, whereas the answer that your client would have given would have been what? That in their opinion, there aren't any.
That you cannot be an evangelical Christian whose lifestyle is one which endorses same-sex activity, I think is what they would say.
So if that's what he means by gay and lesbian,
yes.
Then it's not that it's not known, but the evidence, for example, of Reverend Mason is that they would not qualify.
Yeah, they are not evangelical. They don't fall within the definition of Clause 5, and that is in fact reflective of the wider evangelical community. So
for the judge to go on and say it makes it certain that they don't have the largest, most diverse number of potential applicants really takes the argument no further forward.
No, indeed. And in fact, and we say, if we were forced to adopt those who claim to subscribe to evangelical beliefs but do not conduct their lives in accordance with traditional biblical morality, then that would be undermining of those who have signed up to Cornerstone for its Christian evangelical ethos. So it would actually have a negative effect. Particularly, of course, against the background, as we've already said, that there are plenty of other agencies. There is no problem at all in terms of becoming a local authority foster care, because it would be unlawful for the local authority to discriminate on grounds of sexual orientation, since it's a core public authority when recruiting foster carers. So the law is already protecting gay and lesbian, whether they call themselves evangelical Christians or not. They can continue to foster and adopt. It's just that they cannot do it under the aegis of Cornerstone, because if they do, then it undermines Cornerstone's religious ethos. And that's the only restriction. It's nothing more than that. But I think what's motivating or is behind Ofsted's approach is that that's offensive, because effectively you're allowing an island of homophobic virus to remain supported by the state. There are compelling state interests to the effect that shouldn't be allowed to happen. But it's never been articulated in that way. There is a reference to, in various, certainly in the Chief Inspector, Ms Spielman's various public speeches published on the Ofsted website, to need to be pursue a course of muscular liberalism and not be cowed by presumably muscular Christianity. But there it is. It's never been made express as to why it is that Ofsted have come in on this in this way. So that's the background. That we've got we've got a contradiction in the judgment which cannot be resolved in the manner in which the court tried to resolve it, because it created a category which did not exist and gave reasons for it, which, when looked at carefully, are not supporting them. So against that background, I then look at the specific grounds of appeal which we have remaining, and I would hope that I'm certainly getting through the note of argument. We're page 35 of 50, so I think we're on course to finish today. Against all that background, we then consider second ground of appeal, which won't have to be considered if I'm right in ground one, whether Cornerstone's religious requirement constitutes direct discrimination because of sexual orientation. Now, the court below held that Cornerstone could not rely, at least in relation to matters relating to sexual orientation, on the religious organisation general exception set out in paragraph 2 to Schedule 23, because they fell into the, I was going to say trap, the provisions of 210, which is to say that you cannot have a requirement relating to sexual orientation if you are acting on behalf of the local authority and under the terms of contracts, both things now. Yeah, that's what he found. But just because that is his finding, that doesn't mean to say that therefore what Cornerstone has done is any form of unlawful discrimination. There still has to be shown to be a breach of the relevant provisions of the Equality Act, namely sections 13 and 19. Now, we say that the present case is, whatever it is not a case of direct discrimination against gay and lesbian individuals or against same-sex couples because of their sexual orientation. And remember that the test is because of, under section 13. Because we know that heterosexual individuals and opposite-sex couples who are unable or unwilling to subscribe to the statement of belief and or the statement specifically in paragraph 10 of the Code of Conduct that God's gift of sexual intercourse is to be enjoyed exclusively within Christian marriage, and accordingly to undertake to abstain from all sexual sins, which are then listed. One can be, that category, those requirements can be applied to, and have been applied to, unmarried heterosexual couples, for example, or people who conscientiously say, actually, no, I think the expression of sexual intimacy is something which needn't be confined within a marriage, and there's a moral argument to be made for its expression in other ways. If one held to that, it doesn't matter what your orientation is at all. So it cannot be said simply because, and I think this is what is being said, simply because one of the sins listed, sexual sins listed, is homosexual behaviour, in addition to viewing pornography, fornication, adultery, cohabitation, immodesty. Therefore, it is indissociable from sexual orientation. It is dissociable from sexual orientation. There is no direct mapping on to it. The requirement.
This is 180, is it not? 180 and 181 of the judgment? I'd like to keep track of what the judge is saying about these issues as we pass through them.
Oh, I'll find the judgment, sorry.
Firstly, am I in the right
Yes,
part of the judgment?
Yes, it is, yes.
And effectively what the judge is saying is that even though you have a list of things in the nature of sexual sins, you're caught by one of them, which is homosexual behaviour.
Yes.
And the fact that somebody doesn't qualify under all of them, or other different ones, is neither here nor there.
Well, I say that is an overly broad reading of direct sex discrimination. The court relies on its judgment on the case of Perry against Bull, and that is why we should look at that, because it is also relied upon by Ofsted, and that's the authorities bundle at tab 30, page 917.
Sorry, tab 30.
Tab 30, page 917.
Thank you.
This is the decision of the Supreme Court in relation to the issue of a bed and breakfast, private bed and breakfast, which was run by individuals who were Christians who, since the mid-1970s, had applied a policy of not allowing rooms with double beds to anyone who was not married. It wasn't a place for a dirty weekend. you could have a room with twin beds, but not a double-bedded room. And it was a very, very long-standing policy. And then the policy was implemented in the case of a same-sex couple who apparently hadn't seen that requirement on the booking form and turned up at the guest house and asked for their room with a double bed, and were told that they were reserved to people who were heterosexual married couples, is what, interestingly, the policy was stated to be on the booking form. They pointed out they were in a civil partnership, and I think, as I recall, the couple weren't quite sure what that was. It was all relatively recent. But in any event, we said that you're not married on that basis. They refused to give them a double-bedded room while allowing them, if they wanted, 2 separate rooms, or I think a twin-bedded room. The couple then, rather than take up the offer of another room, immediately went to the police, in fact, and complained of sexual orientation discrimination. The same-sex couple then sued the bed and breakfast with the help of the Equality and Human Rights Commission, and the matter then ultimately came to the Supreme Court, which divided 3-2 on the issue as to whether or not this was direct or indirect discrimination. Well, what I note from this case is, first of all, as I've noted, the requirement was specifically related to sexual orientation. We see that at paragraph 9 of the judgment, page 922, where Barnes Hill notes that their online booking form is stated here at Gilmorva. We have few rules, but please note that out of a deep regard for marriage, we prefer to let double accommodation to heterosexual married couples only. Thank you. The twin-bedded and single rooms, on the other hand, could be let to any person regardless of marital status or sexual orientation. Now, what we may note from this is like the Catholic care case, in the sense that there is no imposition of a religious requirement. They don't say Christian marriage, they say heterosexual married couples. So it is a requirement which is expressly and specifically related to sexual orientation. Although the evidence was it was motivated by sincere religious beliefs, it wasn't a religious requirement. So we're in a different situation to what is considered here. The other important point, as was pointed out by Barnes Hill, is that this case was about a couple in a civil partnership. There had been another case which was coming up and had gone before the Court of Appeal with a couple who were not in a civil partnership, and that had been given permission to go to the Supreme Court, but for reason it was then withdrawn by the couple. So Barnes Hill makes specifically the point that this is a case about civil partnership, same-sex civil partnership. And in effect, the judgment of Barnes Hill focuses specifically on the regulations, which were somewhat difficult to interpret, which said that for the purposes of comparison, civil partnerships are to be treated like marriage for discrimination purposes. And Barnes Hill then says that is correct for effectively one has to treat this same-sex couple as if they were married, because civil partnerships are treated as if it were marriage. And therefore, when they were told they couldn't get the room because they weren't married, they were married, so therefore the only discrimination that could have been was by reason of sexual orientation, so therefore it was direct sexual discrimination on grounds of sexual orientation. So it's specific to the particular statutory framework which related to civil partnerships and its equivalent to marriage, which resulted in this rather narrow finding, which was dissented from by, I think, Lord Neuberger and
Lord Hughes.
Hughes, yes,
Yes.
Lord Hughes.
Right, so at the bottom of paragraph 14
Yeah.
explains what you've been telling us.
Yes. So, what that means then is that this case is not direct, is not some kind of general principle to the effect, as Ofsted seems to think, that the religious belief requirement in this case, which doesn't refer to sexual orientation, and as such, it has to be equated to be direct discrimination. What it has to be equated to is indirect discrimination. I accept that, as I accepted it in Preddy and Bull. And I do that on the basis of the decision in Rodriguez against the Minister of Housing, the 2009 Gibraltar decision from the Privy Council, where it says in terms there that at paragraph 19 of that decision, which, as the court will recall, was to do with the imposition of a requirement, a policy of a statutory body responsible for allocation of government housing, that only couples who were married or had a child in common could get a joint tenancy. The Privy Council says this in paragraph 19. In this case, we have a clear difference in treatment, but not such an obvious difference in treatment between the appellant and others with whom she seeks to compare herself. The appellant and her same-sex partner have been denied a joint tenancy in circumstances where others would have been granted one. They're all family members living together who wish to preserve the security of their homes should one of them die. The difference in treatment is not directly on account of their sexual orientation, because there are other unmarried couples who would also be denied a joint tenancy, just as there would be unmarried couples in our case who would be denied the application of foster carers. But even if that, as the court will have found, that is the proper comparator, the effect of this policy upon this couple is more severe than on them. It is also more severe than in most cases of indirect discrimination, where the criterion imposed has a disparate impact upon different groups. In this case, the criterion is one which this couple, unlike other unmarried couples, would never be able to meet. They will never be able to get married or to have children in common, and that is because of their sexual orientation. Thus, it is a form of indirect discrimination, which comes as close as it can be to direct discrimination. But it's indirect discrimination. Now, of course, in our case, we're not in that situation of it being impossible for people of a particular sexual orientation to agree to adhere to the code of practice and to accept, as a matter of religious requirement, that God's gift of sexual intimacy as to be enjoyed exclusively within the bonds of Christian marriage. It is perfectly possible for any gay or lesbian individual or same-sex couple, well, actually gay or lesbian individual, because if you're a same-sex couple, then the conduct and lifestyle would appear to contravene the requirements of compliance with traditional biblical morality. So it's indirect discrimination if it's anything, it's not
right. So if I understand it correctly, that you challenged that this was direct discrimination in the present case. You accept that it was indirect discrimination, but you say it was justified.
Yes. That's it in terms. And I say it's Preddy against Bull is in the same situation as the Catholic care decision, which we looked at earlier on, but we're in the photographic negative of that because we're in a situation where we're not applying a requirement relating to sexual orientation, but a religious belief requirement for which approval had been given already by the Charity Commission. Just to bear in mind, of course, that for the purposes of direct discrimination, Section 23 requires that there be no material difference between the circumstances relating to each case for it to be direct discrimination. Whereas our religious belief requirement distinguishes between applicants based on a whole range of factors related to whether or not the applicant subscribes to and lives by the tenets of evangelical Christianity as a whole. It's not focused on sex. So often people think that religion is obsessed by sex, but as is clear from the whole series of what constitutes good and moral behaviour, it's number 10 in a list of 11. And as you said, so Cornerstone rejects applicants who are not married or those who are married in opposite sex couples but don't wish to abide or live by biblical doctrine. So whatever we're doing is not discriminating solely or indissociably on grounds of sexual orientation. The other distinguishing factor from Preddy is, of course, in Preddy involved a real couple. It was real people. And so therefore one could say, well, these are the facts of this case. In this case, this couple were, same-sex couple were in a civil partnership. As we've said from the outset, it's rather difficult to make a direct discrimination case when you don't have any victim or individual to say who has been discriminated against. Now, Ofsted say at paragraph 37 of their note of argument that a regulator such as Ofsted is not required to identify a victim of discrimination by Cornerstone in order to conclude that the policy directly discriminates against foster carers. And it refers to a decision of this court in the Al-Hijra school case, which is at number 22 of the bundle. But that decision doesn't support that claim, because in the Al-Hijra case, as the court will recall, that was to do with the lawfulness of a religious school's policy of segregating male and female pupils. And the evidence that was produced to the court was that, in fact, this was causing harm to the female pupils because of the implicit claims of girls had to wait longer, and weren't allowed a break, and implicit suggestions of inferiority between the sexes. So Al-Hijra then is an authority for when you've got victims, then you can look at the facts, and that's what you'd expect. It's not authority for Ofsted claiming to be a freestanding or freewheeling human rights regulator who can identify wrongdoing in the abstract and exercise effectively its regulatory powers with a view to stopping Cornerstone continuing to act as a religious body with its particular religious ethos.
Well, the judge dealt with this, didn't he, at paragraphs 261 to 269. He said the arguments put forward on Cornerstone missed the point.
Well, that's what the judge thought, and that's why we're appealing against them, lady. I don't think it does miss the point. Just because the judge below rejected it doesn't mean to say that it's wrong. We have noted the issue of the requirement for there to be a victim, which is clearly exists within the convention jurisprudence, which there's no doubt in Article 34. It's also contained in Section 7, I think, of the Human Rights Act, the requirement that there be a victim. But it is disapplied in relation to the Equality and Human Rights Commission, which is given statutory standing as victim under the Equality Act 2006. Now, the issue about whether or not a regulator could claim there was a breach of rights on behalf of non-identified victims was considered and decided in the Northern Ireland Human Rights Commission case in relation to the prohibition on abortion in Northern Ireland, continued prohibition. And that was before, I think, a 7-judge decision of the UK Supreme Court. This court will recall that the court split in all sorts of ways, but the majority said that the Northern Ireland Human Rights Commission did not have the statutory authority to bring the case in the absence of a victim, because it had not been invested with statutory victim status in the way that the Equality and Human Rights Commission had been. The Northern Ireland Human Rights Commission was not able to do that, said the majority. The minority said, well, it didn't really matter because they could always find a victim. It was court knowledge that women could be identified, who could have been brought, and therefore they ruled that the continued prohibition on abortion in Northern Ireland was convention incompatible. But so the issue of regulators having or not having statutory warrant by way of victim status to raise convention rights is a real issue, and is not one which could simply be dismissed in the manner in which the court below did so. This is a real issue not simply from a purely technical point, but from the fact, as the Strasbourg case law may explain, is that you need to know the facts in order to establish whether convention rights have been breached. You cannot do this in the abstract, because apart from anything else, all it needs is an imaginative lawyer to come up with an imaginary victim who fits all the requirements, even if one never exists in real life. So that's why I say it is important and should properly be considered by this court, notwithstanding the dismissal by the court below on that point. And as I say, nothing which has been said by Ofsted in fact supports their claim that they can go ahead without having identified a victim, for there to be a finding of direct discrimination against whom.
And you would say, because of the very way in which the Code of Practice is formulated, together with the Statement of Beliefs, there would never be a victim.
Yes, we would absolutely say that. And the interesting thing is that the judge had to create a victim. I mean, Ofsted sort of floated past those suggestions of gay evangelical carers without any evidence, and it was picked up by the judge. But that's where the judge was led astray. So we come on to the next ground of appeal, which is also the fourth ground of appeal. The court will be glad to know, in the sense that we're dealing with the justification issue. Because if this is to be understood as indirect discrimination, of course, we say I shouldn't have to be dealing all this, because we say that section 193 has given me the buy on that. But that having been said and understood, now, in terms of any justification exercise under section 19D of the Equality Act or under Article 14 of the Human Rights Act, the issue is effectively to apply a proportionality exercise in that classic way of identifying a legitimate aim, seeing that there's a rational connection between the aim and the means, that the means chosen are the least restrictive alternative to achieve that aim, and finally proportionality stricto sensu, that looked at overall the result is one which is conscionable or proportionate. There's some dispute or discussion in the case law as to whether or not that fourth level applies in EU law, but certainly it has been adopted as a matter of convention law and really more generally in the common law. The Bank Mail Act case, certainly in the Supreme Court, points to that four-stage process. Now, we say that Ofsted are misrepresenting our justifications. Ofsted say at paragraph 45 of the note of argument that, in essence, we are putting forward an argument that the exclusion of lesbian and gay carers is justified by Cornerstone's sincerely held religious convictions alone. Well, it's not that. We've pointed out in our evidence and in our skeleton the substantial and concrete benefits to Cornerstone's carers and to the children cared for by them in this in the application of this policy. And this is accepted by Ofsted in their own updated report. and it's worth looking at that report at this stage, I think. And that's to be found in the the supplementary bundle at tab 14, pages 213 to 215. Doesn't help that in my print-off copy there's an overprinting of the numbers, but it's the smaller typewritten numbers on the bottom right.
So on the right page, if I've got start with 214.
Yes, and it's an exhibit to the third witness statement
Yes.
of Lisa Pascoe, who says that this is the revised statement that was produced following the judge's hand down to take account of his finding that there was no breach of religious discrimination on grounds of religion.
Yes.
So, we see at page 215, first of all, key findings from the inspection. This independent fostering agency requires improvement to be good because, first bullet point, the agency's recruitment and selection policy for foster carers is not inclusive and does not comply with the requirements of the Equality Act. The agency requires applicants to refrain from homosexual behaviour and practice will only accept married heterosexual carers. It therefore discriminates against those who are not heterosexual, contrary to Article 14, read with Article 8. So that's the main complaint, but we then go on to, at the bottom of that page, the independent fostering agency's strengths. It says the majority of children's cases seen at this inspection demonstrate they live in good quality, stable and permanent placements.
We've read this.
Oh.
I mean, there's a long list of strength. There's a list of other forms of scope for improvement items. We can take those, I think, as read.
Yes.
We're concerned with the first one at the top.
Yes, it's the first one which then determines where it is that they're failing, because in other objective concerns, they actually say there's a positive benefit. I mean, just over the page at 216, it says the agency provides a specialist, as part of its strengths, a specialist faith-based support service to carers. Foster carers have reported enhanced levels of resilience and ability to care for children as a direct result of that support. So it's the point to be made is that we are not, as Ofsted seem to be suggesting, saying that what we are doing is proportionate because of our religious beliefs. Those religious beliefs are actively resulting in positive outcomes, which Ofsted themselves have reported on and recognised in noting the positive feedback given by policing authorities and children in relation to the practices, as well as the general, the fact that many children have been adopted by carers, often from large sibling groups and children with complex needs, and that carers have reported they get support from Christian prayer and from individuals who share their perspectives and values. But the inadequacy of the reported inadequacy, which Ofsted finds, is not to do with the quality of the care, but to primarily the fact that an Ofsted view, the requirements of the Equality Act and Human Rights Act are not being complied with by the imposition of these religious requirements. So, there are benefits which Ofsted have noted, so that has to come in terms of any justification exercise. So it's unlike many of the, we actually do have facts here, nicely, which actually are supportive of a finding of justification of any indirect discrimination. So that it shows that Charity Commission, at least, is not completely off the wall in having ultimately reached that in relation to proportionality exercise. Section 193. There's a reference Ofsted make at paragraph 49 saying that they received a complaint from a person, but that's nothing to do with sexual orientation. The complaint was it was about religious belief. It's at page 127 of the bundle. It's an email exchange. The supplementary bundle.
Mine's at 124. 124 to 125, I should say. It's a bit overprinted on my version. Let me go back and 9 the pages and count forward.
Yes.
Yes, and the exchange is there, starting at the bottom of 125. Hello, thank you for contacting, supplying expressive details. See you through a Google search. We're a Christian charity. Have a genuine occupational requirements in all posts, including foster carers. We assess facts and conditions in married couples only where unique in the UK in this regard. You don't specify your faith relationship status. If you're able to meet the criteria, we're happy to discuss. Now that seems to have been then sent on by this individual, and there's no further information on it. I am disturbed that they are clearly articulating a view which discriminates against my belief system. As far as I'm aware, religion and belief are a protected characteristic. I'm informing you of this because it flies in the face of fundamental British values. I say it's actually totally in accordance with fundamental British values, the subsidiarity aspect, but it is a claim about discrimination on grounds of religion or belief, and that has been found by this court and has not been, the court below, and has not been appealed to be a justifiable requirement. So it provides no support to Ofsted. Shows how few factors that have no complaints. If no doubt if they had complaints in relation to sexual orientation or from the National Secular Society or whatever, they would have produced them, but that's all they've got. But in any event, Ofsted arguments, as we've said, fail to engage with the central problem in this case, which is that they accept, because the court below ruled, that our religious belief requirements were justified as a matter of law. We did go through a proportionality exercise before the court below. As we had done before the Charity Commission, it is possible to go through that again, although there are dicta, particularly in Z against Hackney, to say that it is the first instance decision maker who makes the proportionality analysis, and it's not open to an appellate court just because it would reach a different view to redo that proportionality analysis. I say that applies mutatis mutandis to the fact that the Charity Commission in this case reached a view, and it wasn't open to the court to require it to go through it again. But that is on the basis that the courts below's proportionality analysis was not vitiated by error in law, if and insofar as it was, and we say it was because of the fundamental contradiction in saying that they were lawful religious belief and requirements, but not lawful on sexual orientation requirements, then it is open to this court to, if so advised, do its proportionality analysis anew, against the background that, unlike in the court below and unlike what Ofsted's position was in the court below, it is now recognised that a legitimate aim would be the preservation of Cornerstone as a religious organisation participating within the public sphere and providing its charitable benefits. That there is worth in maintaining that kind of pluralism within a democratic society. And we know that the Cornerstone, as a religious organisation, is applying a religiously based provision, criterion or practice. We say that given the legitimate aim for that criterion of practice is the maintenance of Cornerstone's religious ethos, the application, the imposition of it in the circumstances is rationally connected to that legitimate aim. Cornerstone's religiously based belief requirements, the PCP, is in the circumstances the least restrictive alternative available to it, because without it, Cornerstone will be unable to maintain its specific religious ethos as an evangelical independent fostering agency charity, which, as we've seen, provides faith-based support services. So that's the requirement is the least restrictive alternative to maintain its evangelical identity. And so, and on the fourth limb of the proportionality test looked at in the round, the fact is, as I've said before, gay and lesbians are able and willing and indeed are welcomed within some agencies as foster carers and adopters. But what is not, and the fact that Cornerstone continues its work with all the positive benefits associated with that, albeit that it is now reflecting older values which are perhaps not courant or au fait. The fact is that those values are not ones of, or to be stigmatised as not worthy of respect in a democratic society, or a simple continuation of bigotry and the like, particularly against the background that we know that their approach to and definition of marriage and the idea that sexual activity be confined in marriage is one which is a mainstream Anglican belief among other Christian churches. So against the background that we do have that legitimate aim, we say that the proportionality test would be passed if applied by this court.
Could I just ask you about the evidence on this? Because this, as the judge said, is very much a fact-sensitive evaluation. I've just been looking at the statements by Mrs. Birtles in order to understand what the role of belief and prayer are in the actual running of the agency. That there is a custom of prayer at the beginning of meetings and so forth, and there is a clear amount of evidence, not surprisingly, that carers in these demanding positions gain from the support and the religious fellowship and advice which is offered to them.
Yes.
But these carers are all around the country in many different circumstances. That it isn't like as it were, a meeting in a hall or a church where everybody's there at the same time. So one could understand that if you were having a meeting at which you had some people who were very signed up to the objectives of the organisation and others less so, that might have a critical effect on the dynamics of what was going on. It's not a situation which depends crucially upon group meetings at all. It's a situation that depends, as I understand it from the evidence, as would be the case in any fostering agency situation, on a close and supportive and mutually respectful relationship between the agency and the family. And of course, with the family, you've got to take into account the fact that with older children, those older children may themselves not hold any particular religious belief and are not expected to. So at the moment, I'm struggling with this idea that having somebody who isn't fully signed up would be like the pin in the balloon, whereupon the whole thing would start to unravel to the disadvantage of everybody involved, to the disadvantage of the children involved. Because these are not, in a sense, town hall meetings. these are a series of important bilateral events, and there may also be other events with the staff, which are group meetings, as one would expect in any organisation of this kind. So can you, as it were, respond to that impression from the evidence, which was certainly the impression I think that the judge received?
Well, I would refer immediately to Ofsted's own report,
Yes.
which says at page 221 in tab 14, foster carers are provided with appropriate preparation to undertake the fostering task. Foster carers receive regular qualitative supervision which provides them with opportunities to reflect on their practice and ensures that children have a positive experience and receive good quality care. Foster carers are highly complimentary about the support received from the agency and the events and the holidays which the agency offers. So I don't think that this can be reduced to, as it were, a limited telephone prayer on a one-to-one basis. This is an agency with an ethos to which all are committed and all participate, and there are, as I understand it, communal events. This is not some kind of atomistic relationship between individual carers as a whole. And the evidence, which is uncontradicted, is that the prayer issues are done with foster carers at staff meetings and at holidays and events for foster carers. So it isn't simply that, as it were, the one-to-one, and therefore if you had a different foster carer, it's like Ofsted saying, well, you can go into another room to pray. That's not how it works. But once you've got a person who is not committed to your beliefs and refuses to accept the consequences falling on from that, it has an undermining effect in the whole thing. It means that you no longer have that ethos. You've got a different ethos. You've got more of a, not quite anything goes, but a plurality of views which you might or might not accept. That would mean, as the judge says, it will still have a religious ethos, but it just won't have Cornerstone's religious ethos. And so the maintenance of that, which permeates everything which Cornerstone does in its management and its support and its events and its holidays, it cannot be compartmentalised. That's asking it to become a different kind of agency, and for Cornerstone, not a religious agency, not one with an evangelical Christian ethos. And this is an agency which, as we've said, and as the court has noted, in which the carers, children and policing agencies have all been highly complimentary and been given positive feedback, and it's been effective in supporting adoptions of large sibling groups and children with complex needs, resulting in their positive outcomes. If there were negative issues in terms of outcomes, that would be an issue, but it's not. It's a theoretical notion that somehow things are wrong because of the application of these religious requirements seem to be inimical to the full diversity of potential carers who would not be evangelical Christians. And we've found that, the court below found they were justified in maintaining a restriction on evangelical carers for all the reasons which have been set out. So what would be being suggested is we can be something other than an evangelical Christian, almost a Christian, or a different kind of Christian. There are undoubtedly gay and lesbian individuals who account themselves Christians. Of course, there's absolutely no doubt about that. It's not just the Roman Catholic caucus of the lesbian and gay Christian movement which holds to that. But the issue is who Cornerstone considers to be, for the purposes of its work and its mission, to be evangelical Christians. And it is those who live the faith through their personal lifestyle and conduct. As I say, it may be thought old-fashioned, it may be thought unfashionable, it may even be found offensive that they should be maintaining that position. But that's the thing about a democratic pluralist society, is that we don't all have to agree. In situations in which positive outcomes are being given for these children, where good works are being done, and it's going to be stopped. Why? Because of a theoretical worry or complaint or concern by Ofsted, which is not backed by any individuals or backed by any evidence at all, and it's all to do with suppositions. Why then say, as Ofsted says, because its report says it's not just a report as the Judge Below seemed to think, it's just a report. It says, unless you have a limited period of time in which you have to change your existing religious belief requirements in order to comply with our understanding of what the Human Rights Act and the Equality Act comply. And if you don't do that, you'll be deregistered. And if you maintain that, and it's also saying you have to do that because you're acting unlawfully, and if you're acting unlawfully, your charitable status comes into question. So the issue is, of course, you can continue acting as a religious charitable institution as an independent foster agency, but only on our terms of what we think is acceptable religion.
The prospect of this leading to the closure of the agency was one that the judge wasn't prepared to countenance. The evidence of Ms. Birtles was that a lot of local authorities won't deal with agencies that do not have at least a good ranking.
Yes. And the only reason this doesn't have a good ranking, which is why this judicial review is here, because why it's not theoretical, is because of the claims that they're acting unlawfully by imposing the religious belief requirements. It's not to do with the outcomes for the children. The evidence is that that is positive. So of course there are ramifications that go beyond this, with Ofsted's claim that this agency is acting in a discriminatory and unlawful fashion. And of course local authorities with that kind of finding, and therefore it is not good, again I'm going to say, the local authorities who have reported positively to Ofsted on their experience of their placements with this agency are now being told for theoretical reasons that this is no longer a good agency and that it is acting unlawfully, and potentially, no doubt, local authority solicitors will be told you better not do that, engage with that agency, because you too then will be party and complicit in their discriminatory unlawful activities, and therefore you have to cut all ties with them. That's what's happened. In a sense, that's what's intended, I think. I think Ofsted would prefer that this agency no longer function as a Christian evangelical agency.
Mr O'Neill, no doubt you can take me to it, but looking at the key findings, and in particular the table set out at page 217, what does the IFA need to do to improve? There are a list, it goes over 2 pages of what needs to be done, but not all relate to discrimination.
We say the fundamental ones relate to discrimination because it's...
So can I just stop you there? Is it your surmise that the reason Ofsted have given the grading they have is to do with discrimination rather than an actual statement from Ofsted? And if so, please, can you take me to the statement?
Yes, there's a statement to the effect that the effectiveness of leaders and managers is inadequate, and I think that's at page 220, on the basis that the agency requirements and selection process does not comply with the requirements of the Equality Act and Human Rights Act. The agency only recruits foster carers and heterosexual managers. The agency's policies and recruitment discriminates against potential carers of a different sexual orientation. So,
no, it deals with other matters as well. I mean, you picked up the final one on page 220.
I think we're on 222, are we not, in the paper bundle, is leader management inadequate. But the other 2 domains of the 3 that are covered, require improvement to be good. So I think my lady is just exploring why you say that it's just this issue with which we're concerned that has taken the measure below good, when in fact there are 3 measures, none of which achieve good.
We know that in 2015 the rating of this agency was seen to be good, and that on the basis of the what was.
Yeah. Well, we're looking at this one.
Later.
We're looking at this report.
And one of the criteria, which it sets out as why it is inadequate, is the failure to comply with the requirements of the Equality Act. So it is clearly a consideration which we say is a wrong consideration.
Yes,
which
I have that, but
yeah.
the short point is there are other considerations as well which take it below.
Yes, but we don't know what particular weighting was done in that, other than they have taken into account and have set out as their primary issue at the very start issues around the Equality Act. And we know that at page 218 that in terms of actions to be taken, statutory requirements, an agency must be carried out in accordance with the relevant requirements. In this section, relevant requirements means the requirement of any other enactment, in particular to comply with the enactment, section 13, 19 and 29 of the Equality Act and section 6 of the Human Rights Act, not to discriminate on the grounds of sexual orientation in the recruitment of foster carers. Now, all of the previous ones, recommendations, can, without compromising the religious ethos and nature of Cornerstone, be complied with. But this requirement cannot be complied with without compromising and ending its specific religious ethos and the basis upon which the whole charity was set up and has operated to date. That's why I say it is an important point, because just as is said against me, only gay and lesbians are affected by a prohibition on homosexual behaviour. I say that only a religious agency, because of its religious requirements, which have been found to be justified by the court below and accepted as such by Ofsted, will be adversely affected by and will be unable to comply with this statutory requirement, and therefore will not ever be able to achieve a good rating with local authorities, because of what we say is an unlawful requirement which they are unable to comply with if they are to maintain their religious organisation status. That's why it's important.
To go back to the issue raised by my Lady Justice Davies, if one goes to page 214, there are 3 items which are said to require improvement to be good, or 2, and 1 which is said to be inadequate. Those are then, I'm sorry, I'm going back over ground which has already been trodden. One then takes oneself to page 220 when those 3 items begin to be discussed one after another. At 220, one has a lengthy description in relation to this heading, which is overall experiences and progress of children and young people, which require improvement to be good. And for example, in the 4th paragraph, there's reference to a small number of children having experienced unplanned moves, etc., and there are issues about formal matching. That seems to be something which is outside the issues in relation to religious doctrine. Then there's reference to the Christian prayer, etc. And in the final paragraph on page 220, one gets to the bold statement that the agency's recruitment policy is discriminatory. And so that is threaded in under that heading. But nevertheless, there are other matters, as my Lady Justice Davies said, under that heading. The next heading is on page 221, and that's the second matter, which needs to be improved to be good, which is how children and young people are helped and protected. That seems to be concerned with matters which are wholly outside the framework of the religious theological object. There's no reference there whatsoever. And then one gets the third matter, effectiveness of leaders and managers inadequate, and that is foursquare within the terms of what we're considering. So I'm sorry to lay it out so tediously, perhaps, but there are elements, therefore, aren't there, Mr. O'Neill, in those pages to which I've referred, which refer to matters which are outside the, if I can call it, the doctrinal dispute.
There are areas, and we're not suggesting that this court itself then give a good rating to Ofsted. All we are saying is that we should have the opportunity of fixing those matters which we can fix to regain our good rating. But the problem, and why we've had to take this judicial review, is not over any of those requirements which we can doubtless work upon and fix, but on the requirements to change and remove our religious requirements, which, as the leadership noted at page 220, at the bottom of the page, says the agency's recruitment policy is discriminating in that it includes prospective carers. Although this had not directly impacted on the experience and progress of children and young people in the cases seen, it does not ensure that prospective carers are considered without prejudice and appropriate emphasis. So even in that finding, there has been no adverse impact on the actual children. So, as I say, we will fix what we can fix, but this is an unfixable requirement, which requires, therefore, us to stop being who we are, which is a religious doctrine.
I'm sorry to say this and say this so late in the day, but I'm not so sure about that, in the sense that if you say that there are no evangelical Christians who are also going to live in a way which is contrary to that line in the clause in the Code of Practice in paragraph 10, then isn't the answer that one leaves paragraph 10 at set a high standard for personal morality and leaves it at that and waits to see whether there's a real case in which someone who is gay or lesbian and considers that they match up with all your requirements is nevertheless refused as a foster carer.
Yes, but the state has required a religiously based requirement to be removed because the state finds it unacceptable. Now, of course, that's what the court below has said, but I say that is entering into the Erastian forbidden zone.
You say that's unacceptable editing?
Yes, that it's not for the state. We've got all the Article 9 case law and the other matters which I refer to more broadly, is that it is not for the state to say this is acceptable religiosity and this isn't. This is what a membership really is and isn't, and that's what's being required, and that's why I've set that out at the outset.
And I fully understand that. It just seems to me that at the end of the day, and given your stance in relation to the religious beliefs and the incompatibility of those beliefs with somebody not believing that sexual activity is within a heterosexual Christian marriage, then in fact no harm will be done by striking out that line.
Yes, the harm will be done by the state requiring this independent religious organisation to express its religion in a manner which is acceptable to the state. That is a constitutional harm. That's why I say that the Fulton and City of Philadelphia case is actually rather important, because of course one might have a view that that would be the better, more progressive, less...
No, that's
all
not
sorts
what I'm
of
saying.
views.
I'm just saying without that line, in fact, your beliefs would be unchanged.
But this is the line which has been approved in our Memorandum of Association and our Code of Practice, and is in accordance with which we act, because we are required to act in accordance with our charitable instruments. So again, yes, it would be possible, and some other agencies, religious agencies, might well take that kind of view. They would still be religious agencies, but it would not be Cornerstone.
Well, Mr Neal, I completely understand. It's not for us to negotiate with you or you to negotiate with us. That if your position is lawful, you're perfectly entitled to express it in the way that you choose to, and it's really for us to decide whether it's lawful or not.
Yes, I think that's right.
Of course.
And just, I mean, I was interested in your footnote about Fulton and looked into that case, but obviously that's illustrative and interesting material. There they were concerned with a very, very large agency, which meant that the cities barring them from continuing would mean that many children would go unplaced. That was clearly a major feature of that case, as indeed was the reverence that is paid in the states to the First Amendment rights of religious freedoms. So I fully, if I may say so, because you've mentioned it 3 or 4 times now, for my own part, I fully accept that this is interesting comparative law.
Yes.
But it's comparative law.
And I go no further than that. It's also an interesting compromise decision in itself, but it does focus on the strength of the fee, because it was a unanimous decision. Yes. on that part. Yes. The only dispute in the concurrence was whether or not this was in fact a universally applicable law under this. Yes, well,
it's a fairly clear signal that they'll be back to consider Smith in due course.
They've been trying to for, I think, 30 years or so, ever since Scalia came out with it. But it's purely of comparative interest. But it does show an interesting common law approach. And as I say, the free exercise of religion is not peculiar to American constitutional law, just as the free establishment strictly is not peculiar to it either. There are establishment clauses in the Treaty and Acts of Union establishing both the Church of England and the Church of Scotland. I can wrap up fairly quickly on my 5th ground. I know
Thank you very much.
It's quite a big one, but I think it's only fair that we should finish.
My lady definitely has to leave at 12:30, so we will, if you can finish it by 12:30, that would be very, very helpful. Thank you.
That is definitely my plan. The 5th ground is interference in Cornerstone's own convention rights. Now, I say it's significant in this case that there's no dispute that Cornerstone, even if it is a hybrid public authority, has convention rights. So this is an issue of it being able to publicly express its religious beliefs, to associate and to act in the public square in a manner consistent with those. Now, Ofsted will say, look, but this is impacting on sexual orientation and discrimination, so you need weighty and convincing reasons in order to seek any justification of that. But I say, look, weighty and convincing reasons is a fine dictum from the European Court of Human Rights. It sort of seems to be echoing some of the US jurisprudence about strict scrutiny and rational basis scrutiny and intermediate scrutiny. But the fact is that unlike in the US, in the UK and in Strasbourg, there is no hierarchy among the protected grounds. Sexual orientation discrimination is not more protected than religious discrimination or religious rights or protection against discrimination on grounds of religion. We have dicta, for example, the Manusakis case, which is the Authorities Manual 34, page 1056, paragraph 44. It just notes there, as a matter of case law, the court has consistently allowed contracting states a certain margin of appreciation. The court's task is to determine whether measures taken at national level were justified in principle and proportionate. In delimiting the extent of the margin of appreciation in the present case, the court must have regard to what is at stake, namely the need to secure true religious pluralism, an inherent feature of the notion of a democratic society. Further, considerable weight has to be attached to that need when it comes to determining whether or not a restriction is proportionate in terms of Article 9.2. The restrictions imposed on the freedom to manifest religion by the provisions of that Greek law call for very strict scrutiny by the court. So we have, of course, every fundamental right is fundamentally important, but sexual orientation discrimination, because of this, the dicta about weighty, I see your weighty, and I show you my very strict scrutiny. The question about Article 9 being able to be paid in aid was discussed in the case involving Blackpool Borough Council, which is in the bundle, but it's not disputed in this case. So simply refer to that en passant. But as I've said, we do have this last part does rather show the sort of topsy-turvy nature of the attempts to try and square the circle in the court below, because the court below found that, as I've said, the religious belief requirements were justified under section Schedule 23. It was a religious organisation. You can only be justified under Schedule 23 if it's what you've done has been in accord with your religious purposes. And that has been held to be established. I've already pointed out the judge held it would be fundamentally incompatible if under Article 14 they were, as a religious-based fostering agency, couldn't restrict their services to persons holding the faith. So that's not in dispute. That's what we've got. But that nonetheless, the judge then goes on and says, despite all that, there isn't any breach of any convention rights on the part of Cornerstone, although, and he sets that out in paragraphs 297 to 301, and I've already quoted aspects of that before the court. But frankly, it does seem to be predicated on a very strange understanding of Article 9 in particular, because he doesn't really look at 10 and 11, he just says for the same reasons. In a sense, the judgment, because it's so long, seems to rather lose steam, like myself at this stage of the day, and it doesn't focus down on what it's actually saying. Instead, you get these things saying, well, they're not interested in converting, proselytizing, they can worship quietly in the way that they want. But as I've said, paragraph 298 of the judgment, it is a statement that from the judge as to how Cornerstone can properly fulfil its Christian mission. Now, clearly we are in the realms of Article 9. I find it impossible to understand how it could be thought otherwise. We've got the case of Preddy against Bull, in which the court proceeded on the basis that Article 9 in that case was engaged by two religious individuals imposing a requirement on how they would run their bed and breakfast. If that gets in the ambit of Article 9, then all the more so we do, which we're not just running a bed and breakfast, we're living out a Christian mission in charitable activities focused on assisting children. As I've said before, it's not for the judge to have said that Cornerstone can have a religious ethos, it's the religious ethos which it determines. It's not for the judge to determine who its membership might be, the gay evangelical Christian it talked of. The Court of Human Rights has said in the Asplin case it's uncontroversial that religious bodies and political parties can generally regulate the membership only to those who share their beliefs and ideals. That's a situation that we are in. So, frankly, against that background of Article 9, against the decision in Preddy, against the autonomy principle and the right of religious organisations, as this is accepted to be, to set out its membership and declare its own doctrines, the decision of Ofsted at issue by requiring the kind of change which Lady Justice Asplin has suggested is most definitely an interference and an unjustified one. No justification has probably been offered for it by Ofsted.
That falls directly into this category.
I'm sorry, Lady.
That falls directly into this category.
Yes, it does. And,
yes.
And it also falls directly into 10 and 11 because we're associating and we're expressing our views in our mission and work. So, for all those reasons, the judge has long wrongly refused to accept that Ofsted's requirements under its report that Cornerstone drop or change its religious belief requirements in order to accommodate Ofsted's concerns about theoretical discrimination in relation to sexual orientation has the intent or effect of ending the possibility of Cornerstone continuing to function as the religious organisation which it is now. And that is disproportionate interference in terms of freedom of religion, free expression, freedom of association, and that's it.
Any questions from my lady?
Yes, thank you.
Thank you.
Mr O'Neill, thank you for the care you've taken to finish within the time. Thank you very much for your submissions. Shall we resume tomorrow at 10:30 to hear Miss Hannett? Thank you very much.
All rise. Now in the